All right, everybody, welcome to session 1.3. This is where I'm going to be laying out some fundamental legal principles that we use in the United States that will be important to understanding some topics that will come later on. This class involves a fair amount of law around nonprofits, and so I'm going to use this class session as a way to lay groundwork that will make sense of future topics. The goals for this day of class: I want you to be able to explain the federal legal system, to explain how the common law system works versus legislative law, explain how certain constitutional rights, what those rights are and how they're important to nonprofits, identify and explain the legal characteristics of persons, corporations, and trusts, and then some issues that relate to the enforcement of the law, like types of civil claims, standing, jurisdiction, and something called justiciability. Where does law come from in the United States? In most countries, it comes from legislatures or some equivalent lawmaking body, and part of that is true in the United States, but not entirely. The U.S. has a pretty unique legal system in a variety of ways that we're going to highlight right now. First of all, we use what's called a federal legal system. And what it means for it to be a federal system is that we have a federal power. This is a national legal power. And the U.S. Constitution gives the federal power certain rights, things that it's allowed to do. Laws it's allowed to create or enforce. But then in the U.S., we have a set of corresponding state powers. And what you'll notice is these overlap in some areas and they're distinct in others. And what this means is there are some things the federal government is allowed to do that states cannot. And there are some things that states are allowed to do that the federal government cannot. Now, what powers do they have in common? Well, they can all levy taxes against individuals or other entities within their jurisdiction. And they can establish courts to enforce their own laws, which makes sense. An example of something that's unique to federal powers is the power to regulate what's called interstate trade, which is commerce that crosses state boundaries. This is why states, by default, cannot charge a sales tax for something you bought in a different state. Only the federal government could do that. No, they don't. They don't have a federal sales tax, but they could create one if they wanted to. And then on the state side, states are allowed to create criminal laws based on whatever they want. Federal powers are only allowed to create crimes based on existing other powers. But states are allowed to, make anything a crime as long as it doesn't violate the Constitution or something. States can regulate trade or commerce that happens within their boundaries. That's why they're allowed to charge a sales tax for sales made within the state of Utah. And they're allowed to regulate something called, they're allowed to regulate the health and safety of their residents. And this is something called the police power. Now, these blur all the time. And, but it's not that there's not an actual distinction. It's just that the distinctions between what federal powers can do and state powers can do is very much case by case. Now, what's cool about this legal system is it allows states to engage in a lot of legal innovation, to come up with new ideas and strategies that they can do without it having to be a national law. And I'll give some examples of that as the semester goes on. To illustrate how those laws turn into real organizations that enforce real laws against nonprofits, I'll just show some examples here. On the federal side, for example, you have the Department of Treasury, who oversees the federal tax code through the Internal Revenue Service, or IRS. That's really important to how the nonprofit sector works. And the IRS can enforce certain laws against nonprofits and their leaders. And then the Department of Justice enforces criminal law that exists at the federal level. At the state level, this is, again, not a full list, but you have an attorney general who can enforce laws against nonprofits. The attorney general is the most powerful person in any state when it comes to making nonprofits do things. And they're allowed to bring certain actions against nonprofits that pretty much nobody else in the world can do. States always have a Department of Commerce, or sometimes this role is with the Secretary of State. And this is where you set up new nonprofits. This is where you tell the state of Utah, for example, hey, I want to create a nonprofit. You do that through the Department of Commerce. There's obviously a tax division to enforce tax laws and an employment division to enforce employment laws. Now, another thing that makes U.S. law unique is that we use something called the common law system. And common law is what you get when you give judges the power to create legal rules that are better fit to specific circumstances, rather than waiting on a legislature to pass a law. We just tell our judges in the United States, hey, you can create laws where needed to create just outcomes. And so let me illustrate how that works. Now, common law goes back hundreds of years. We imported our common law system from the United Kingdom. And so I'm using an example that would have been relevant 800 years ago just as much as today. But let's pretend that Steve buys a cow from Mike and then Steve doesn't pay for the cow. Well, Mike is obviously going to be upset and he's going to sue Steve. And so judge number one is going to look at this situation and say, you know what? I think it's only fair that if you agree to buy something, courts can make you pay for that thing. And so here the judge creates a law. And that law is if you agree to buy a cow and you don't pay for it, well, then a court is going to make you pay for it. And that's the first law around this issue that was created by Judge One hundreds of years ago. Well, a year later, Adam bought a cow from Beth and then didn't pay for it. And so now Beth is suing Adam. And judge number two is going to look at that situation and say, you know what? Judge number one was really smart. And judge number one saw the exact scenario I'm saying now and came up with a good idea, which is a fair outcome, which is if you agree to buy a cow, then the courts can make you pay for it. So judge two just uses judge one's decision and then makes Adam pay for the cow. Now let's go to year number three, where Mary buys a cow from Cole but doesn't pay for it. Now, based on those facts alone, you would say, okay, it's obvious what we do. We make Mary pay for the cow. And so Cole sues Mary with the same assumption, but Mary comes to court with evidence that the cow is defective. And it's pretty good evidence the cow is defective. Now, I'm not a rancher. I don't know what makes, or a veterinarian, so I don't know what makes a cow defective. But if Mary can persuade the court and say the cow is defective, then judge number three is going to look at this and say, you know what, judge number one's decision doesn't really apply here because Steve bought a good cow from Mike and Adam bought a good cow from Beth, but here Mary is buying a defective cow from Cole, and that's not fair. And so judge number three is going to take number one's decision and then improve it or amend it or adapt it to create a new law that allows for this new circumstance. And this is how common law is built. And so, like I said, it's founded in English law. We imported it into the United States, and we still use a bunch of common law principles that were written hundreds of years ago in the United Kingdom. It's based on judicial decisions, like we talked about. We basically give judges power to create laws where they're fit to accomplish purposes. Judges have to respect the decisions of previous judges, though. They can't just like create a new law whenever they want. They have to use the precedent or the prior decisions of judges in the way they make their decisions. And then we get this cumulative effect where we add up this big pile of law that now affects the way our legal system works. Legislative law is different, though. And the way legislative law works is it's what you're more accustomed to, which is the idea of legislatures or other elected representatives creating laws. Our Constitution was the creation of elected representatives, both at the federal level and at the state level. And then the Constitution created legislatures and Congress who then can create statutes. And then legislatures and Congress can empower agencies to write regulations. And all of these are examples of legislative law. Now, legislative law always overrides common law unless the common law is relying on a higher order legislated issue. So if a court creates a common law interpretation of the Constitution, then Congress has to change the Constitution in order to override the judge's decision. And so that's what I mean when I say that legislative law is always subject to the overriding or more important law. Now, constitutional law, specifically the U.S. Constitution, has some protections or provisions or rights that are important to the nonprofit sector that are worth mentioning. Again, there's more than what I'm mentioning here, but I want to talk first about the First Amendment. The First Amendment enshrines a number of rights. One is the right to free speech. Nonprofits rely on this heavily, especially advocacy nonprofits that are promoting a particular cause. The First Amendment, even though the right of association isn't written there, courts have interpreted it to include a right of association. And that means we have the right to group together to do stuff collaboratively. And that's how nonprofits work. And then, like we talked about in session 1.2, with the importance of the religious history of nonprofits in the United States, obviously the free exercise of religion is a fundamental constitutional right that's important to the nonprofit sector. Some of the constitutional rights that are important to nonprofits are found in the 10th Amendment, even though this doesn't directly relate to nonprofits, but it does indirectly. The 10th Amendment contains something called the Residual Powers Clause. And this says that if the Constitution doesn't grant a specific right to the federal government, then those powers or rights go to the state governments. And this is why we have nonprofit laws, so many nonprofit laws existing at the state level. This is why you incorporate with a state, not with the federal government. And so this is important because you can sort of choose the state where you want to operate because of the Residual Powers Clause. Let's talk briefly about legal entities, and we'll talk about how the law is enforced. A legal entity is basically someone who can be a party that is given powers and rights under the law. People are legal entities, for example. They can sue and be sued. They can own property. We tax them. What's unique about persons is that the rights of people are what are called natural rights. Our legal system is founded in the belief and philosophy that people have certain rights just by being people, not because the government says they have the right, but because their identity as a person grants them that right. and then we sort of enshrine those rights into our legal system, like in the Constitution. Corporations are different because they only exist because state law says they exist. There's nothing requiring states to allow corporations to exist. If states wanted to, they could get rid of corporate law. And that's why their rights are statutory, meaning their rights only exist because the legislature says they do. But still, when corporations do exist, they act a lot like people. They can sue and be sued. They can own property. Obviously, they're taxed or not taxed in the case of nonprofit corporations. Trusts are a form of legal entity that are a little weird because technically they're kind of like a mix between a contract and people. And so in some ways trusts are they can sue and be sued, but it's not the trust itself that's sued, but it's the trustee that gets sued. They can own property, but it's the trustees, the people who run the trust, that own property. But we do tax them, so we treat them like legal entities for tax purposes, and their rights are also statutory, coming from legislatures. And like I mentioned already in the first two class sessions, the majority of nonprofits are set up as corporations. Let's talk about how the law is enforced. It begins with a cause of action. This is an event that gives rise to a legal claim. If you sort of have a wrong done to you personally, you have what's called a civil claim, where the law says you can go to court and the court has the power to make it right by forcing the other person to pay you money, to make them stop doing something or whatever. So this is where there's a wrong done to a person. Criminal law usually involves a wrong done to a person, but what makes it a crime is that it's also a harm or wrong done to society. And this is why only the government can bring criminal actions. You've heard of the term pressing charges, but pressing charges doesn't mean that you as a person have an ability to force a criminal charge against somebody. Pressing charges means you're pressing or encouraging the prosecutor, the government lawyer, to bring criminal charges. And so crimes are treated differently in that way. And the thing that's unique about crimes is that the government has the power to put you in jail, for example, if you commit a crime. The government can't put you in jail for a civil law violation. And so enforcing the law, once we have a cause of action, enforcing the law requires standing, jurisdiction, and justiciability. A standing is the right to pursue a claim in court. So if you want to sue somebody, you have to have a good reason to sue them. You have to have standing to sue them. And to have standing, it means you have first a personal claim. The wrong happened to you and not to somebody else. Secondly, what happened was unlawful. So they broke the law in creating that wrong against you. You can be wronged, for example, in ways that don't actually break the law. And then you have a chance for relief. And what that means is the court has a way to make it right. Not entirely right, but to do something for you, to uphold the law. So they can force the other party to pay you money, make them stop doing things, whatever. So that's where standing comes from. And a lot of legal issues around nonprofits are interesting because of standing issues. Now, if you want to bring a civil claim because you've been wronged in some way, you'll probably bring it for one of these three reasons. These are the most common types of civil claims. A tort is anytime you were injured, basically, or your property was damaged. And so that wrongful act that led to the harm to you or your property, whether or not it was intentional or accidental, can give rise to what's called a tort. My favorite legal term is related to tort law. I'll tell you in class what that is. It's a fun word to say. Contract law might be another reason you sue. This isn't because like you had an injury done to you, but because somebody broke a promise to you. And that promise has to involve what's called consideration. And consideration is where the parties to a contract agree to exchange things that have value. And so anytime there's an agreement for the exchange of consideration, that creates a contract. And contracts are legally enforceable. So the court can basically either make you follow the contract or make you pay for breaking the contract. And then finally, a third category is called a statutory claim. And this is just a claim that came because a legislature said it does. And I'll tell a story in class about something called the Consumer Sales Practices Act, which gives you a statutory claim against somebody who rips you off. Finally, the last item to talk about is jurisdiction. And jurisdiction just refers to the fact, I've got two more things, sorry. Jurisdiction is the second of the three. And jurisdiction is where we sort of define what sorts of legal issues courts are allowed to make decisions about. There's no court that can decide everything. Not even the U.S. Supreme Court can decide every legal issue, because that court can only oversee federal legal issues. And there are some state law issues that the U.S. Supreme Court has no authority over. So we limit it by the power, right, that the court derives its enforcement actions from. So like the federal constitution and the state constitution. We limit court's jurisdiction by geography. So we say, hey, court, you can only decide cases that sort of came up in this geographic boundary. That's what this map shows you. This is an older map of U.S. federal circuit courts, where it shows you if the Ninth Circuit, for example, covers those states, and it can only make decisions related to issues that arise out of those states. And then the last way we divvy up jurisdiction is we make it topical, meaning that sometimes we create special courts to decide just specific areas of the law. And so this is the case with juvenile courts. Delaware has something called the Chancery Court, which decides corporate issues and disputes. And so sometimes we give courts special jurisdiction over particular areas of the law. If you're a court who's been asked to make a decision that's outside of your jurisdiction, you have to turn it down. And you say, sorry, I can't decide that. The last element to talk about is justiciability. And this is where the issue that the court is deciding about has to be enforceable. And these are the elements of justiciability. The decision has to make a difference. It can't be what's called non-advisory, meaning you can't just ask the court for their opinion. They're not allowed to just give opinions. They're only allowed to make decisions about real issues, where their ruling changes an outcome. The plaintiff obviously has to have standing. The facts have to reflect a substantial controversy, meaning like there's something going on that relates to the law, and that's ripeness, and it can't be already resolved, because if an issue has already been resolved, then it's moot and the court won't decide on it. And finally, to be justiciable, the issue has to be not purely political. And purely political it's got fuzzy boundaries around it, but the core principle or idea is that if it has to do with like something that a legislature has been given power to do and not the courts, then courts need to stay out of the way. All right, and that's it. So we'll see you all in class next time.